Good evening, everyone. If you can't hear me at the back and that bothers you, do wave a hand or move forwards. Welcome to this talk about what's been termed the Russian aviation case. It's particularly poignant today, the 4th anniversary of Russia's invasion of Ukraine. I'm Kermit. I'm going to introduce the show and introduce my colleagues. First of all, we've got Tom Nixon on the far right, called almost 10 years ago. Tom has a broad commercial practice in litigation and arbitration. People Tom blackmailed to speak to the directories have said that he is phenomenally bright, even by the standards of the English bar. And there aren't enough words to describe how brilliant Tom is, which is a bit of a cop-out in my view. Suffice it to say that Tom and I have worked together on many cases, and he's not only a joy to work with, but I seem to have run out of words. Joseph England is sitting next to Tom. He's ranked in the directories in 6 categories, spanning aviation, insurance, fraud, arbitration, energy, and insolvency. And you may think that all of those issues arose in just one case, and you'd be right. But his roster of cases show how adept he is at winning cases for his clients across the panoply of commercial dispute resolution. If that's my mum, can you tell her it won't be very long? He's described by one of the directories as being an articulate and very intelligent junior who thinks outside the box. And you can judge for yourselves at the end of this evening, and we'll take a straw poll. Matthew Reeve, to my right, is the organising force behind our aviation practice in Chambers. He took silk in 2023 and has appeared in courts at all levels in the UK. His client list is enviable, boasting members of royal families, senior military figures, 3 Premiership football clubs, international sportsmen, well-known business personalities, in addition to aviation authorities, insurance regulatory authorities, and of course insurance and reinsurance companies. One of his director entries describes him as brilliant. He's clever, funny, and can do the commercial side as well as the personal injury side. Again, you'll judge for yourselves, and we'll take the straw poll. I'm Robert Temmink. I have a broad commercial practice, which means that my cases are broadly the same. Someone hasn't paid for what they should have paid for, or somebody hasn't done what they should have done. The subject of that naughtiness usually involves things that float or fly or are immovable or intangible. The amounts in dispute are usually so large that there's an insurer somewhere lurking around, and the amounts are so large that usually there's an insolvency practitioner lurking around as well. I don't know about your experience of commercial dispute resolution, but almost every case in which I'm involved now involves allegations of fraud or conspiracy, and that holds true in jurisdictions all over the world. I'm too embarrassed to say out loud any of the hyperbole you'll find in the legal directories about me, but you'll find me listed in aviation, commercial dispute resolution, arbitration, fraud, the Middle East, which apparently is a category, and chancery commercial. Now, before I talk about what we're going to address tonight, just a little caveat. The Russian aviation litigation continues. There's an appeal, and there's the operator policy claim, which is going to begin in October this year. And we won't talk about things that might impinge on either of those things, particularly since there are loads of defendant lawyers sitting in the room anxious to hear what us who are acting for the claimants have to say. What we are going to talk about is this. First of all, Tom is going to kick off with an outline of the facts, the issues in dispute, and in somewhat of a spoiler alert for those of you who haven't read the judgment, he'll summarise the result. The baton then gets passed to Joe, who's going to talk about some of the practicalities thrown up in huge cases like this one. Matthew will then talk about 2 issues of law, grip of the peril and cancellation notices, and then I'll have the graveyard shift between you and your drinks to talk about construction, not about building, but about legal construction, and what decisions were made on some of the wording that arose in this case, and we see in insurance policies commonly. And then finally, there'll be a chance to ask questions, and Matthew has kindly agreed to field all of those questions, and give you detailed answers which you can rely on legally on the most complex issues you can think of in the next 40 or so minutes. So without further ado, hand over to Tom.
Thank you. Domestic civil aviation is crucial to Russian society. That's not a hyperbole, it's just a fact of geography. Russia's the largest country in the world, spans 9 time zones. 65% of its ground is subject to permafrost, preventing proper road infrastructure. So to take an example, the city of Yakutsk in northeastern Russia, it's an important mining town with a population of over 300,000 residents. Flying there from Moscow takes 6 hours. Driving there from Moscow, allowing for the bare minimum sleep for you to not hallucinate, would take over a week. So as a result, there is a large industry of Russian airlines, ranging from majority state-owned, such as their national carrier Aeroflot, to fully privately owned. This litigation involved about 20 airlines, but there are over 40, depending on how you count them. But there's a strategic weakness underlying all of this, and that's that the commercial aircraft used by Russian airlines are almost all Western-made. They're Airbuses and they're Boeings. And more importantly, for present purposes, these aircraft were in large part owned by companies in the West. Now, estimates vary a little bit, but likely well over half of the commercial aircraft operated in Russia were owned by Western lessors, and the airlines merely operated them under the terms of a lease. So with that background, let's look at the timeline. On the side. Turns out I have to switch it on. On the 24th of February 2022, Russia invades Ukraine. It was widely reported that President Putin was expecting swiftly to capture Kiev in 3 days. Today, as Robert said, happens to be the 4-year anniversary of the conflict. On the 25th of February, the EU announces a full package of sanctions. And this took the form of an amendment to the sanctions that were imposed following the annexation of Crimea to make them much more wide-ranging. And they included a prohibition on the supply of aircraft for use in Russia. So that includes leasing your aircraft out to a Russian airline. And the UK and the US followed suit shortly thereafter. On the 26th of February, the heads of several airlines in Russia were called to a meeting at the Russian Ministry of Transport, often referred to as Mintrans, with the Minister for Transport, Mr. Savelyev, who also used to be the CEO of Aeroflot. What happened at that meeting is something we'll come back to. It was the subject of much dispute. And at around the same time, on the 26th of February, the lessors started sending the airlines notices demanding the return of their aircraft under the terms of their leases. And they usually relied on either sanctions clauses or clauses about maintaining proper insurance or material adverse change clauses. Although by the time we reached trial, it was common ground that all of those notices, at least the ones governed by English law, were valid and they should have been complied with. The 28th of February, there was a further meeting held at Mintrans, again with heads of airlines, again subject to lots of dispute. On the 1st of March, war risk insurers who insure these aircraft start issuing 7-day cancellation notices. And these give 7 days notice of their intention to cancel war risks insurance insofar as it pertains to Russia, Ukraine, or Belarus. We'll come back to that again later, but remember the date, 1st of March. And those notices would have taken effect 8 days later, which was agreed to be the end of the day on the 8th of March. On the 5th of March, FATA, who is the regulator of civil aviation in Russia, circulated a message to all of the Russian airlines. And I quote in translation, "In connection with the unfriendly decisions of a number of foreign states, Russian airline companies and passengers have become tools and hostages of the political fight. In this connection, FATA recommends to Russian airline companies that have aircraft under a lease agreement with a foreign entity, in summary, to cease flights abroad to countries where there was a risk of arrest." Now that word recommends in the notice was subject to a lot of argument for reasons we'll see. And then finally, on the 10th of March, Government Resolution 311, often referred to as GR 311, was brought into force. This was a formal government resolution that banned the export of aircraft from Russia. Now, all of that happened over the course of 2 weeks. And I mean, interestingly, in an important sense, that's actually the end of the relevant timeline. Because since then, essentially nothing has changed. GR 311 was initially expressed to take effect only until the end of 2022, but it has been subsequently extended. It's still in force, extended, I think, until the end of 2027. And with very few exceptions, these hundreds of Western-owned aircraft are still in Russia, being flown either within Russia or to allied countries, often long after the expiry of the terms of the relevant leases. And the net effect is that if you take a domestic flight in Russia, there's a good chance it's on one of these aircraft. So the Western lessors swiftly brought claims under the terms of their insurance policies, saying that their aircraft had been lost and claiming their insured value. 5 claimant groups ended up having their claims tried together at a 3-month trial starting in Michaelmas 2024, including mine and Robert's clients, Merck's, and Matthew and Joe's clients, Genesis. Let's look at the key features of the relevant policies. Now, of course, the policies did vary a little because there were many claimants and many aircraft, but these are the common threads. The claims being tried before Mr. Justice Butcher were the lessor policies, or LPs. Many of you will be familiar with this. Broadly, there are 2 sets of insurance policies in play. Under the terms of the lease, the airline is itself required to take out insurance and to grant the lessor third-party rights to sue under it. But those are the operator policies, the airlines being referred to as operators. But lessors also tend to take out their own policies, broadly speaking, to ensure continuity of cover between leases and to protect against the risk of something going wrong with the operator policies. Some of my colleagues will touch on that a little more in due course. The lessor policies generally covered all risks of physical loss and damage. It was common ground that physical loss includes a loss by deprivation of possession. So it doesn't just cover the case where your aircraft crashes into the Andes and breaks apart. It also covers situations where you just lost possession of an asset that's still in one piece. War risks, as is conventional, were excluded from this all risks cover under standard form AVN 48B, and then they are underwritten again by a different market. So functionally, you end up with, it can be structured as 2 separate policies or simply an all risks policy with a war risks endorsement, but you've got 2 sets of insurers, one covering all risks and one covering war risks. And both sets of insurers were sued, and both sets of insurers pointed the finger at the other. War risks, the standard war risk clause is quite lengthy. For present purposes, we can just focus on the fact that it includes restraint and detention by or under the order of any government. That's the limb that the parties and indeed the judgment focus on. As mentioned earlier, the war risks cover generally, but not universally, contains clauses entitling the insurer to revoke cover or change geographical limits on 7 days' notice. So those are the key features of the policies. I'm going to try and summarize what findings were. It is absolutely impossible to do justice to all of the sub-issues of fact and law that were raised at this trial. The judgment is over 1,000 paragraphs long, and I think we were all pleasantly surprised that it was only 1,000 paragraphs long. The big ticket issues were, at least in my view, for present purposes, has there been a loss under the terms of the policies? Were these aircraft actually lost in any meaningful sense? What does a loss mean? Isn't there a chance that the lessors will get them back? When did that loss take place? If that loss happened after the expiry of the policy, is that fatal to a claim? What was the proximate cause of that loss? Now, this was the major issue that took up the vast majority of court time, if I may say so. Was this a war risk? Was this a government restraint? Now, I framed my introduction based on the Russian state's interest in civil aviation, so hopefully I've primed you to think that that was obviously the cause of the loss. But one can paint a different narrative where the government has very little to do with what was happening at all. It was, I suppose, broadly common ground that the collapse of the Soviet Union led to the birth of a generation of business leaders who were very strong-willed and rather powerful. And they fought valiantly to create these airlines, and many of the large airlines are still family businesses. And so it was said the leaders of these airlines were never going to just hand over all of their aircraft, which were vital to the functioning of their companies and would inevitably lead to the collapse of their business empires. So the question was put, well, is it not likely that the airlines privately decided that they would keep these aircraft long before the government told them to do anything? And might it not have been that these meetings with Mintrans were in fact the airlines lobbying the government to support what they wanted to do, rather than the government telling them what to do? And this dispute led to months of court time being used, trawling through emails, public documents, history books, and the like, with the assistance of expert evidence from Russian politics experts and Russian aviation experts, all to assist the court in determining which of those stories is the most likely. Was this a government-driven retention, or was it a privately driven theft, to use shorthand? Now, judgment was handed down last summer, and the answer to those questions were as follows. So the test for loss. Now, perhaps surprisingly, on the authorities, it was quite unclear what the proper test was for a total loss by dispossession under a non-marine policy. And there was some argument about whether the policies incorporated a marine concept of constructive total loss, but none of those arguments succeeded. But in the non-marine context, Mr. Justice Butcher reviewed the authorities and came to the conclusion that the test could be quite simply stated. The question you ask is whether the deprivation of possession is, on a balance of probabilities, permanent. It was common ground that the policies didn't cover temporary dispossession, and so it was common ground that to one extent or another, we were asking ourselves about permanence. But there was a lot of dispute as to what precisely the test was, and that's what Mr. Justice Butcher found that it was. And there was a question as to what permanence means. Does it really mean permanent, or should it be judged by reference to the commercial life of the aircraft, or perhaps something shorter? Should it instead be a reasonable time rather than permanent? And Mr. Justice Butcher says he finds in the context of an insurance of aircraft, permanence naturally means the commercial life of the aircraft, saying although AerCap, another one of the claimants, protests that that's a long time and it's difficult to say what will happen during such a long time, this is catered for by the test as to the degree of certainty there must be. As I said, I consider it to be whether on the balance of probabilities the deprivation is permanent. That there is a possibility of return during the lifetime of the aircraft does not exclude that the insured may be able to show on the balance of probabilities that the deprivation is permanent. So the fact that one can hypothesize about scenarios in which all of the lessors happily get their aircraft back tomorrow does not mean there has not been a total loss. You have to look on the balance of probabilities, is this permanent? On the facts, Mr. Justice Butcher found that there was such a loss, and it took place on the 10th of March. So in paragraph 911, split it out into two. In the first section, he talks about before the 10th of March. He says at that point, the recovery of the aircraft was uncertain. But on the 10th of March itself, essentially the scales tipped. He says, I consider that it could and would properly have been said to be unlikely. By that stage, there was a formal ban on exports. That was the last item on the timeline we were looking at earlier, GR 311, and effective practical restraints on flying to locations where there might be return to lessors. Western sanctions were in place for the foreseeable future. While GR 311 was, as enacted, time-limited, it was likely it would be continued as long as necessary to counter Western sanctions, and it has indeed been extended. The probability that, upon any hypothesized end to sanctions, which might be years down the line, and having been flown or kept unused in Russia in the meantime, the aircraft would be returned to lessors, would, in my view, have been considered to be low. So given that he found that the loss took place on the 10th of March, unsurprisingly, he also found that the proximate cause of the loss was a war risks peril, that is, a restraint by way of GR 311, the export ban. Items 1 to 3 on that sub-list essentially say that GR 311 banned the export of aircraft as the culmination of a plan that had been developing. I must say, I'm taking it as read that GR 311 was in fact a ban on the export of aircraft we had a week of expert evidence from Russian customs lawyers in order to determine whether that was in fact the case. But thankfully, you don't need to be troubled by any of that. Item 4 on the list, I think, is quite interesting. He says, under most regimes, but especially under an authoritarian regime such as Russia's, obedience to an enactment such as GR 311 can be expected. It was to be expected that from its enactment, airlines would comply with it, whether or not it represented what they would have otherwise have wished to do. Compliance with the law will have displaced or replaced, as of prime importance, any other reasons which the airlines, or some of them, may have had to retain aircraft. So what Mr. Justice Butcher is saying there, and it's reflected in other parts of the judgment as well, is that as a matter of causal analysis of the proximate cause of the retention, the government's order under GR 311 obliterated, essentially, whatever private interest the airlines might have had in keeping the aircraft anyway. So we've got a total loss, that's good for the claimants, that's taking place on the 10th of March, which potentially causes some difficulty for some of the claimants. And that's because, as we looked at earlier, the war risks cover, or at least in some cases, was cancelled on the 1st of March, and that cancellation took effect on the 8th of March. So there was a question as to, well, is the loss still covered? Now, Matthew will expand upon this a little, so I'll only take the point shortly. But Mr. Justice Butcher found that while the loss only took place on the 10th of March, whilst the 10th of March was the day where the scales tipped, and on the balance of probabilities, the deprivation of possession was permanent, the relevant perils gripped the aircraft earlier, during the policy periods, and that was sufficient. So on the facts, the judge drew a distinction between Aeroflot, which is majority state-owned, and the other airlines. So in this paragraph, he finds that at the initial meeting on the 26th of February, the Ministry of Transport ordered Aeroflot to retain its aircraft and not to hand them back. And that was a government restraint. So very early on, the government made a decision in respect of Aeroflot. But in respect of the other airlines, the position was left unclear on the 26th of February. There was a lot of argument about when precisely things crystallized in respect of the other airlines. A lot of people were advocating for the 28th of February at the second meeting, but Mr. Justice Butcher doesn't bite. What he says is that it was the 5th of March in the FATA message that I read earlier, a message from the regulator that quote-unquote recommended that airlines didn't fly to countries with a risk of arrest. And he analyzes that message in its context in light of the expert evidence and the evidence from Russian aviation people, and says, actually, this was an order, despite the word recommendation, expressed in unusually emphatic and political terms, and was communicated by particularly numerous and direct methods. As Mr. Koznov said, Mr. Koznov was an employee at one of the airlines. It would have been understood as a ban of flights abroad for any purposes, and it was largely complied with. So he found that the FATA message amounted to a government restraint in respect of all non-Aeroflot aircraft, and he found that this was sufficient to found a claim under the policies applying the grip of the peril doctrine. And there was a lot of dispute about the grip of the peril doctrine. Again, Matthew is going to expand on this, so I won't take too long. Arguments about whether it was impliedly excluded on our policy wordings, about how it applies to deprivation of possession cases, if it exists in that context at all. Mr. Justice Butcher finds that it does exist as a matter essentially of construction. And I won't read out that sentence because that is a single sentence and I can't do it in one breath. That's we're coming back to that. Well, dare you to have a go. And then at paragraph 966, he essentially ties the knots together, having found that the grip of the peril doctrine exists, says, well, the Aeroflot aircraft were gripped by a war risk peril on the 26th. The non-Aeroflot aircraft were gripped by a peril on the 5th. And so as long as your policy was still alive on those dates, it doesn't matter that the loss took place on the 10th of March. So on that note, I'll hand over to Joe to talk a bit about how all of this litigation was managed.
Thank you. I'm going to talk about some of the practical case management challenges. of this litigation. I thought I'd do so by giving a few statistics to illustrate litigation on a grand scale. So the sums claimed were around 3 billion, as you can see. The number of lost aircraft, around 150. Airlines, as Tom has already alluded to, around 20. The number of claimants was 5, but behind many of those claimants were other related companies and insureds. So actually, although there were 5 major lessors, there were many claims and other related claimants behind them. Then, of course, there were a large number of insurers named as defendants, and in this case, they were largely all named, all those on the slip, rather than just the slip leader. And I counted around 100, if you count the various insured companies separately. The number of counsel was 80 for the LP trial alone. The costs were 120 million plus, with AerCap contributing a fair amount to those. And the length of the trial was 3 months, and as is publicly known, unfortunately, the judge had a health issue during the trial, which also caused it to be part heard and then resumed in early 2025. Then the oral closing and written submissions in total between all parties took around 10 days, in addition to quite fulsome written submissions. Then thank you, then there are around 8 procedural hearings. The expert evidence, as Tom alluded to, some of which the judge ultimately questioned its materiality, but it took 2 months, ranging from Russian politics to civil aviation. The written closing submissions totaled, hopefully it's an appropriate reference, War and Peace, which my copy is 1,440 pages. The judgment was 230 pages, but actually, as Tom says, it's a very concise judgment. It's not one of those which copies and pastes all the submissions. Mr. Justice Butcher zooms in on the important points and the analysis. So actually, as Tom said, it could have been a lot longer. The grounds of appeal are very long, even as well, with the skeleton being 50 pages, and that remains for the Court of Appeal to decide on paper, the permission application. So what were the real case management challenges? Well, there were a lot of claims. The first was begun by AerCap, who were quickest off the mark after the invasion, and in June 2022. And the first really major case manager issue was whether it should be AerCap as the lone test case, or whether other claimants should be heard alongside AerCap as well. And there are obviously various costs and practical arguments, but ultimately it was decided it was better for the market, as well as insureds, to have a judgment that dealt with more policies, potentially other issues. Also, if you just had the AerCap case, AerCap, due to its market clout, doesn't have any cancellation notices, so that wouldn't have been dealt with. Or, for example, as you can see from the judgment, it sought primarily to claim under its all-risk policy, whereas most of the other claimants said it was a war risk, because that didn't have a limit on it. So there were differences in the AerCap claim, and in any event, other claims were heard alongside the AerCap claim. Then, unusually, there was actually a circular sent by Mr. Justice Butcher at one point asking essentially for other claimants to make themselves known or potentially come forward, just so he could get a feel for the size of the litigation. There are also new parties joining. So, for example, the war risk insurer Fidelis applied to be a party in its own right and have its own representation. Some of the other defendants opposed that, saying the issues were similar, they could be covered by the existing legal teams, but the judge disagreed and held that they had something to bring to the table and their economic interest justified them being their own party. My clients, and Matthews Genesis, the leasing company, came last to the party, and just for a CMC just before the disclosure, and that took a lot of work both behind the scenes, particularly with Matthew convincing other parties that we weren't going to cause a problem and we could fit in, and it made sense for our case to also be heard, even though the disclosure was about to happen. Then, even very late on in the proceedings, around the time of the PTR, an insurer, Liberty, from the related OP proceedings, which are going on, asked to be a party so it could be bound by the findings in the judgment. And that application was also acceded to. But the main case management issue really was the interaction or potential interaction between the LP and the OP claims, which the OP claims started with jurisdictional challenges because of the clauses, the exclusive jurisdiction clause in favour of Russia. But then after that, they were then managed alongside, originally by Mr. Justice Henshaw, now Mr. Justice Pickin. And so, just to give you an illustration, it was not so much document sharing or what was going on in the jurisdictional challenges, but it was very interesting. One could look at what certain people were saying in one claim to suit their own purposes and then perhaps point out the difference in the other claim. However, the main point was identified by Mr. Justice Butcher in his judgment at 56, where he talks about several of the defences raised the LP's claims required the court to consider whether the alleged losses suffered by the lessors were recoverable by virtue of claims under the OPs, which were governed by Russian law. This posed a serious problem of case management. And at a CMC in June 2024, several ways of proceeding were considered. Ultimately, he ordered that certain issues would be hived off to a phase 2 trial of the LP, but in any event, due to his decision, that didn't ultimately prove to be necessary. One party, for example, Chubb, was essentially arguing the OP and LP should all be heard together. At the other extreme, other parties were trying to hive up as much as possible to the OP claims. But that phase 2 of the LP, due to the decisions, that in the event has not materialised. Then some practical challenges. Finding somewhere to sit, that's not a joke. It was all by the end very well agreed and choreographed with sort of nice colour-coded seating plans, but there were some undignified sights, not here, but among very senior people, about who should sit where and why at the beginning of the hearings, because there were so many people in the courtroom. There was even suggestion at the PTR that the case would be heard in an external venue because the court wouldn't be able to accommodate it, with one of the leading counsel for Chubb suggesting it be at a certain stadium in Manchester. There were also practical issues in terms of confidential DPSI information due to the sensitive nature of the dispute and some of the evidence. Some of the witnesses gave evidence in private and were anonymised, individual one, for example, same with the experts. And there were a number of documents that were confidential for that reason. But also there was sensitive commercial information regarding some of the claimant lessors. So, for example, when the judgment was sent, there were two versions, one with password protected, with DPSI information, and one with not. But ultimately, whilst that was a case management issue, it didn't make much difference in the ultimate judgment. Then finally, a practical challenge was the balance, particularly for both parties, particularly for claimants, of wanting to get your case across and being heard, but equally avoiding duplication, because there were a number of similar issues. There was limited court time. So, and it's the balance between making sure you're heard, but also not annoying everybody, including the judge, by essentially repeating in a slightly different way what's already been said by others. There's a balance to be struck. Then finally, just reflecting on, from my own perspective, the sort of practical lessons learned, I found in these cases there has to be, and there was, a remarkable degree of cooperation amongst the parties and their representatives, which made the case run smoothly. For example, you will know from bilateral cases between two parties that one can have endless disputes, guidance, hearings and so on about the DRDs. They were all agreed, essentially, by the time of the CMCs. And certain sort of low-hanging fruit, you just don't have time or the court resource to fight. And there was a huge degree of cooperation over procedural issues, which made what was already a very large-scale litigation quite seamless. And that surprised me in some senses, but was a good surprise. And also another example of that would be, for example, when the judge unfortunately was unwell, the case had to be temporarily part heard, there was a remarkable degree of cooperation to then relist the case. My other main lesson for me personally was the Opus 2 bundles, which I initially some suspicion of, but found them to be ultimately invaluable, both for the searches you can do across a huge amount of documents on the file, and which are uploaded throughout the case, but also you can do things like annotate privately within your team the various comments on the transcripts or other documents throughout the proceedings. And also it was very useful to have either live translations, but also the documents up on the screen for the judge and everybody to see, often with a split screen if there were two parts of a document. So I found that to be extremely useful in a way that I perhaps hadn't expected. So thinking about the overall question, did it all have to be as bad? The answer is, in terms of case management, it could have been a lot worse. Hand over to Matthew.
Well, thank you to Tom and to Joe, making my life easier, as I think they've done not for the first time in this case. I can go straight into two issues. First of all, the grip of the peril principle, and secondly, the connected question, the use and effect of war risk notices to review, and the consequent cancellation endorsements under the standard of war risk wording. I think it was recognised very early on that the existence and scope of the grip of the peril principle would be at the very heart of the argument at the end, for a number of reasons which amounted to a perfect litigation stall. The first was there was a remarkably stark disagreement between the parties, or facts and law, as to when the total loss occurred by way of a war risk restraint or detention of the aircraft by the Russian government. The claimant said that the aircraft were permanently lost within a few weeks of the Russian invasion in the first half of March 2022. By contrast, the war risk defendants denied that even at the trial, 3 years later, it could be said that the aircraft were lost because of the chance of recovery even at that stage. And if I can be allowed one sectarian crack, it did seem to remind me of the words of Chairman Zhu Enlai when asked by Mr. Kissinger about the impact in 1973 of the French Revolution, and he's reputed to have said it's too early to tell. That's the last religious point I'm going to run. The second reason why the grip of the peril was really important, or seemed to be really important, was that it was the war risk case that it's not enough for the insured to establish a government restraint or detention which had started during the policy period. They made the point that at first such a restraint might be temporary. You have to wait and see to see later whether it's become sufficiently permanent to be a total loss. And so it was their case that if the detention only became a total loss after the policy period, it was not covered. And that's where the battle lines lay. So to put that in perspective, there's a slightly different version of the chronology to illustrate the point. The earliest policy expiry date was my client's Genesis on the 15th of March, which was 3 weeks after the invasion. Critically, on renewal, Genesis was completely unable to get cover for Russia, perhaps not surprising, and the cost of the renewal of the contingent cover, even excluding Russia, was a premium rate which is 107 times the rate which had been charged the previous year. I'll come back to why that is potentially important. And then the fourth reason why the grip of the peril was important and was always going to be important was the the ability of August underwriters to unilaterally serve a 7-day notice to review the terms, and if the terms, new terms are not accepted, to cancel the cover entirely. As Thomas mentioned, one lessor, conspicuously AerCap, had the economic clout to have those cancellation terms removed entirely. The rest of the lessor market was not as fortunate. They appeared, the cancellation terms appeared in all of the other LP policies. And DAE, Falcon, Merckx and Genesis all received cancellation notices, some of which expired before the 10th of March date found by the judge, as you see on there, before the date when the aircraft was permanently lost. The earliest of those was actually a cancellation notice and endorsement for Genesis, which expired on the 2nd of March. Now, part of the context for that is that throughout the February, Genesis's war risk market had been serving notices, repeated notices to review, some of which sought to reduce the 7-day notice period, first of all to 48 hours, and then to 24 hours. So in fact, the notice that Genesis received to withdraw the cover for Russia on the 2nd of March was received on the 1st of March. So it only had 24 hours effectively to respond to that cover. It didn't manage to get the aircraft out. The war risk defendant's case was that DAE, Falcon, Merckx and Genesis had to prove that the detention of their aircraft had matured into a total loss before the expiry of the notice periods. So it was in that context that grip of the peril was raised and contested. Very quickly, the roots of the principle are in marine insurance, in the idea that if a ship is a fish, you have to develop that one. The ship is fatally damaged during the insured period, but only sinks later. The insurer still must pay because the peril that caused the loss struck during the cover. I think the first use of the phrase "grip of the peril" was in the Scott and Copenhagen case by Lord Justice Ricks in 2003. Ultimately, and interestingly, the existence of the principle and its applicability to aviation insurance and non-marine insurance generally was not contested. The war risks underwriters really only took 2 points. First, they argued that the grip of the peril principle was ousted by way of agreement in the policies because the policies were LOD policies. They only cover losses occurring during the policy period. The DAE policies were expressly LOD policies, but the judge held that the other policies, Merckx, Genesis, DAE, although they didn't use those words, were to be construed in the same way. But he rejected that word, the argument that the use of that phrase, losses occurring during, was sufficient to oust the grip of the peril principle. He referred to the recent decision of the Court of Appeal in Skye and Riverstone, and his essential justification was to go back to the fundamentals of property insurance as a contract of indemnity. The insurer makes a primary promise that the assured will not suffer the insured damage, and the LOD terms are insufficiently clear to exclude the secondary liability for the damages for some or all of the loss, where that loss develops after the policy period. So in the end, the decision turned on quite a simple point about whether the language was sufficient to be an exclusionary term of damages that would otherwise be expected to be paid. It's quite interesting how we ended up there. And I wonder how many people predicted that that is where we would have ended up. But essentially his decision was that the exclusion of a liability for damages needs to be more clearly expressed. The second point that the Warist underwriters argued was that the grip of the peril should not apply to a temporary deprivation of possession before and until it's clear that the deprivation is permanent. Again, that was rejected. And the judge's answer was, I'd say surprisingly, but refreshingly pragmatic. He recognised that if the grip of the peril principle was not applied, then what he called a black hole would open up. So it was fairly illustrated by an exchange between the judge and counsel on day 44. The discussion was about a scenario in which an aircraft is hijacked on day 1. The underwriters cancel on that day, give 7 days notice to review or to withdraw cover. The aircraft is then blown up by the hijackers on day 10. The Warist underwriter's position, when presented with that hypothetical scenario, was that the loss would not be covered because there was no loss by way of deprivation or destruction at the time of the expiry of the cover. And I remember very clearly the judge's response to that was, well, that seems tough. And I think he recognised the unfairness of that. Once the hijack or Warist peril commenced, there was no chance of getting new insurance cover for any eventual total loss for an ongoing peril. So the void beckoned. And obviously it wasn't a theoretical problem, as Genesis' experience of its renewal in March of 2022 revealed. So the judge's response was to deploy that commercial reasoning and say that the grip of the peril principle is implicit in the policies. It seems to be an implied term, and he said it was necessary to avoid the black hole. That's the grip of the peril where we are now. Sorry, he articulated the peril according to the language in paragraphs 963. If an insured is within the policy period deprived of possession of the relevant property by the operation of a peril insured against, and in circumstances which the insured cannot reasonably prevent, that deprivation of possession develops after the policy into a permanent deprivation by way of a sequence of events following in the ordinary course from the peril insured against, which is operated during the policy period, then the insured is entitled to an indemnity under the policy. So trying to unpack that, at its simplest, he was saying that if you have the operation of a deprivation peril operating on the aircraft before the end of the policy period or the cancellation notice, then there is cover if that subsequently after the policy period matures into a total loss by way of deprivation. And 2 points he was keen to make is it does not require there to be even a partial loss or a breach of the primary insurance warranty during the policy period. So I think the conclusion on that, or the summary on that, is that as things currently stand, the justification for the grip of the peril principle is a ruggedly, if not gloriously, commercial one. And there really wasn't much other analysis of the necessary implication of the term. So moving on to the question of cancellation notices and endorsements, I'm going to take this slightly more shortly, just going back to this period. As I said earlier, Genesis had the earliest cancellation notice, and really, after the judge's findings on the grip of the peril, the only one that mattered. And in the end, the effect of the Genesis cancellation notice and endorsement depended on leading underwriter authority. The endorsement was only signed by the leader of the war risk slip. Although it was circulated around the following market, they never signed. I suspect because they felt they didn't need to. The followers relied on a clause in the slip subscription agreement at the end, which conferred authority, single leader authority, on the leader in respect of amendments to AVN 52E cover. Now, of course, AVN 52E is liability cover, whereas the cover that was in issue for the purposes of the trial was the hull cover, or a war cover. So by the end of the trial, the war risk defendants were arguing that the clause contained a clear mistake in referring only to liability cover, and that it should be properly construed on chartbook principles as conferring leader authority in relation to all amendments to the hull cover as well. Happily for Genesis, that failed. It was on the basis that it was not obvious that there was a mistake. The judge speculated that the wording that was included in the policy was one that the brokers regularly applied in the subscription agreement. And even if there was a mistake, it was not obvious that the solution to that on chart principles was to rewrite the clause to allow for single leader authority for amendments of hull cover. I think looking at it from the outside, that is someone who not instructed by the underwriters, I think the episode, it's not unfair to say, revealed some confusion at the time in the market as to how to operate the cancellation provisions. And perhaps unsurprisingly, in what was a fairly fevered market atmosphere following the invasion in February 2022. And I'm going to put this as neutrally as I can. I think that it also raised some genuine questions as to whether it's fair and in the long-term interests of the war market to rely on the 7-day cancellation provisions in future. Thank you. Would you like to?
It's warm in here now. That first glass of wine is really kicking in. You're wondering, is it going to be Deliveroo? Maybe that bit of cheese will get left at the back of the fridge, or are there going to be some snacks? We will have snacks. There is cold wine. I won't be too long. But I've got something to wake you up. Principles of legal construction, everybody. So, in a very careful manual review of the judgment, we found 78 instances of the word construction and 53 iterations of the word interpretation. That was time well spent. The principles of construction obviously loomed large in the judgment and covered the meaning of total loss, the scope of war risk perils, the grip of the peril doctrine, and the correct approach to concurrent, included and excluded clauses. So what was the test? Well, no prizes for this one. The usual principles, starting in investors' compensation scheme, and more recently set out in Wood and Capita for what's applicable to insurance policies. And here we have a quote from FCA and Arch Insurance, from Wood and Capital referring to FCA and Arch Insurance. Core principles in insurance policy is like everything else. You can read the quote. As a side note, Mr. Justice Butcher referred to a few cases suggesting that insurance policies are oftenly, and this will surprise you, haphazardly stitched together with clauses from different sources, and it may be dangerous to try to construe them as if they were coherent. You'll find that in paragraphs 274 and 275 of the judgment. But let's look at something he did say in paragraph 272 of the judgment. It says, I also consider the following statement to be sound and a useful guide. The ease with which an insured may establish matters relevant to its claim for indemnity may influence questions of construction. A construction which advances the purpose of the cover is to be preferred to one that hinders it, leaving massively pregnant what is the purpose of the cover. So is this a not too subtle bias in favour of the insured and in favour of cover? Well, implicitly, that quotation recognises the purposes of insurance cover is to allow the insured to make a claim on it. That's what the insured's paying good money for. If you buy a telly, you're entitled to expect that it works properly and you can watch the television. If you spend your money buying an insurance policy, you're entitled to expect that to work properly. So that when you lose your aircraft because somebody nicks it, or there's been a deprivation, you expect cover to pay out. Of course, with all due deference to the difference in cover between operator policies and lessor policies. So let's look at that difference, contingent cover, and the interrelationship, or the interrelation between lessor policies and the operator policies. All of the claimants owned the aircraft, or were the owners subject to financing on the aircraft, but had them on lease out to Russian airlines. In each of those leases, the airline, the operator, was required to take out its own insurance policy and to endorse it with a standard wording that was designed to allow the lessors to have rights under it as a third party. That's what we call the OP policies, the operator policies. Everyone agreed that in the ordinary course, if there was some form of damage to the aircraft, a claim would ordinarily be brought under the operator policies, either by the operator itself or by the lessor as a third party. And in addition, in these sorts of relationships, the lessors take out their own policies, the LP policies, the lessor policies, and those purported to insure the aircraft against the same aircraft against loss and damage. A key part of those lessor policies then was the so-called contingent cover. And again, it was common ground that the contingent cover under the LPs was intended to be backup cover. The LP contingent cover was intended to kick in when, for one reason or another, the claim under the OPs hadn't worked. Now, my client, Merckx's clause on that topic was pretty simple. Clause 5.5 says, this insurance does not cover loss of damage which is recoverable as a claim from the principal policy, and the principal policy was also defined, the policy or policies required to be effected by the operator pursuant to the provisions of the lease agreement, essentially the OP, the operator policies. And that reflected the nature of contingent cover as backup cover. Now, Merckx and the other claimants did notify a claim under the operator policies, and where the operator policies insurers responded at all, the claims were simply denied. The operator policies generally contained Russian law and Russian exclusive jurisdiction clauses. That was a fun day out, a couple of days out in front of Mr. Justice Henshaw, arguing about the jurisdiction clauses. The lessors generally took the view that bringing a claim before the Russian courts would be pointless. However, claims were brought under the operator policies in England, principally against the European reinsurers nonetheless, and a challenge to jurisdiction by the reinsurers failed on the ground, and this may surprise you, that the claimants would not get a fair trial in Russia. The OP claim, as many of you know, will start in October this year. Claims were also commenced under the lessor policies and the contingent cover, and given that those were subject to English jurisdiction, there was no jurisdiction challenge, and they came on much earlier. As a result, Mr. Justice Butcher found himself trying the claims under the lessor policies in October 24, without any final resolution of the claims under the operator policies, indeed 2 years before they're even listed for trial. And the LP insurers said, well, that's not fair. You can't do that. Turning back to the wording of clause 5.5, they said, we don't know if the loss of your aircraft under the operator policies is recoverable as a claim yet. There hasn't been an OP trial. You might make a recovery. You might not. But in reality, what the insured has done, they said, is improperly made a claim under the backup cover before resolving its claim on the primary cover. And what they said was the court's going to have to wait until the OP claims have been determined or itself made a final decision about whether the OP claims should succeed. Now, the judge summarised my client's claim and I think, therefore, also some of the other claimants as follows. He said, it can't have been intended that to claim under our policy, Merckx would be required first to spend limitless money and unspecified and infinite time chasing down recovery from operator policy reinsurers, potentially in a wide range of jurisdictions in the face of adamant denials from those reinsurers that there's any liability. Merckx contends that claim means simply the making of a formal request for indemnification, and recoverable simply means reasonable steps must have been taken to prevent and advance such a claim. So that's to say, Merckx purchased a commercial insurance product intended to ensure that Merckx was compensated in the event its aircraft were lost and the value couldn't be recovered. And it would be contrary to the purpose of that cover if Merckx were required to litigate under the operator policies in a foreign country all the way to judgment and lose before it could even start a claim under the lessor policies and the contingent cover. And you can bet if it had gone all that way under the OP claims and it had lost, that any claim for the costs of pursuing that litigation under the OP policies would absolutely fundamentally have been refused by the lesser policy insurances. What financial product requires the purchaser to spend indefinite, maybe even infinite money, and certainly indefinite time before it can reap the benefits of the product it's bought? Well, Mr. Justice Butcher accepted those arguments. He said, I consider limitation, that a limitation is suggested by the words as a claim, though I recognise the exact nature of the limit suggested is not easy to define. And we can skip a bit. I think that the phrase does tend to suggest that the recovery should be capable of being made as part of a normal process of claiming under an insurance policy, rather than by way of having to take steps going beyond the reasonable to seek to effect a recovery. Thus, I accept Merckx's case that recoverable as a claim means, in effect, recoverable given the taking of reasonable steps. So the end result was that Merckx was entitled to immediate judgment, notwithstanding its claims under the operator policies had not yet been finally resolved. The burden was on Merckx's LP insurers and reinsurers to seek some sort of contribution or indemnity from the OP insurers if they wanted to. Merckx was therefore slightly too successful in the LP claim, which means that neither Tom nor I need to pursue a claim either in the appeal or under the operator policies, although I'm pleased to say we are available for any reinsurance work, particularly from the all-risk market, wanting us to run the claim against LP insurers on their behalf. So by way of conclusion then, and to assuage the is it Deliveroo, is it the piece of cheese, and when on earth am I going to get another glass of wine, let me sum up like this. As an insured, it can often feel like the terms of a policy are heavily stacked against you. And there often isn't that commercial bargaining power, as in fact AerCap had in this case, to negotiate terms of these incoherent and stitched together policies. Almost every conceivable point, and indeed many points that I couldn't conceive of, were run by defendant insurers and reinsurers, and those points racked up to a 12-week trial with commensurate costs. Costs, of course, money well spent on us lawyers, all of us in the room here, but nonetheless a massive amount of money, 80 million for AerCap's costs in that trial. And all in pursuit of a resolution in circumstances where we'd also bought a policy which that the lessors thought protected them. So in answer to the question we're looking at tonight, does it have to be this hard? There are perhaps signs that it doesn't need to be that hard, and the court will try to read policies purposefully, constructively, and to fulfil a commercial need, which is, I'm pleased to say, entirely what Matthew said in his analysis too. That's it from us. If you have any questions, Matthew's going to field them.
Yeah, I mean, there is nothing that gives me more pleasure than placing a glass of wine in Rob's sight, but keeping away from it for a while. So we will have a few questions, only for that purpose. So just to remind you, the topics we've touched on are the conclusions on loss and peril, scale and procedural challenges, the grip and peril principle, and the construction of the contingent policies. Do we have any questions? That is a surprise.
You are welcome to chat to us more informally, so you don't have to embarrass yourself by asking what you thought was a very clever question.
No, I don't know why in this situation we feel it's a defeat that there aren't any questions. I don't think it is. So I think we'll go straight and we'll give Rob his drink. Can I say a few thank yous? First of all, to the team here at Quadrant for making this event work. Thank you to my fellow team members for all of their work, and particularly the juniors. I mean, they've had a hard job to do. And finally, on behalf of us four and on behalf of Quadrant, we thank you for coming along tonight.